SJC-11363, Commonwealth v. Anthony Mazza.
This is one quick.
Mr. Kuna, good morning. Having just watched that brilliant argument on both sides, I felt everything I was going to say drained from my head.
You're not alone.
Best I can.
Attorney Kuna, I'm confident in you.
Well, I hope so, Judge. As this court is well aware, I represent Anthony Mazza, now in his 48th year of imprisonment. This is the second time the case has been before this court. The issues are essentially in the same posture they were in the first time we were before the court, with a somewhat different composition, obviously. And it involves two separate items that we maintain are newly discovered, and which we suggest to the court are equally deserving of a new trial, but that certainly considered as a whole, and this time we cite Rosario to you. I made the argument last time, before Rosario was decided, that the confluence of the two factors is also something that this court should consider. With respect to the first item, which is the statement of William.
Can I ask you another silly question, perhaps?
I doubt it's silly, Judge, but
I
go
went
ahead.
back to Justice Giles for,
Yes.
for an evidentiary hearing. It wasn't really an evidentiary hearing that she held. I mean, you couldn't find, I guess.
Well, there was one witness.
Well, yeah, but it was your own partner, law
Yes,
partner.
yeah,
Yeah. And then she did make findings, but they're not findings that, you know, were particularly developed at the evidentiary hearing. Do we have to do anything with her findings?
I don't think so,
Do you
Judge.
have any status at all?
I don't think so. I mean, she said she wasn't going to decide the motion and then sort of decided the motion.
Right.
So I don't think so. I don't think there's any, again, I think the case is really in the same posture, unfortunately.
But you weren't able to find those.
I couldn't find them, the government couldn't find them. I cited that in my supplemental reply. There was some suggestion that I should have filed an affidavit, and perhaps that's correct. I'm not going to go there, but I can say that I was relying on the fact that the government also had told the judge they were looking for these witnesses, and neither side could find them.
Yeah.
It's 48 years later. I mean,
Well, after post-conviction, I mean, post-event, I mean, he's been in prison.
well,
for-
it's 70. The incident, the murder itself was on July the 1st of 1972. So that's 47 plus years ago.
Mr. Coon, what do you say about, you're about to get into William, and of course the Commonwealth says, well, the strategy wasn't to impeach William. William was helpful to the defendant. That's their position, I think.
Yeah, I don't even understand that argument, Judge. This isn't impeaching William. This is eliciting affirmative evidence of Robert's culpability. I mean, it's staggering. I asked this court to read Robert's testimony, direct and cross, and the cross was over the course of 3 days. And then read what William said, and then read what the cross of him was, which was basically two questions. One, did you speak to Robert about it? No. And then he asked him the same question again in a slightly different way. And then the second question was, did you speak to your mother about it?
But doesn't William say, essentially, my brother brought me to his apartment, showed me the dead body, and the defendant was in a different room?
He says that, yes. And you mean in his statement?
No, in his trial testimony.
Well, he says but there are things in the trial testimony of Robert that are far more inculpatory. For instance, Robert says that when he gave the ring to William, which was he says on the evening of when the body was shown, he said, "Mr. Tony asked me to give this to you." What William said in his statement to the police was that he got that ring the morning of the like hours after the man was killed. And I think it says that Mr. Mazza was in the apartment at that time. It's unclear because the copy that we have has the name of the person there blacked out. So I'm just assuming it's Tony Mazza, but we don't even know that.
We have two Superior Court judges that looked at all this and said, well, maybe Attorney Inker at that point said, William doesn't hurt me. He puts his brother in the soup because he's showing him the dead body, and I'm done with William. That's
wouldn't want
essentially
either of those two
what Judge Brady and Judge Giles found, right?
With all due respect, Judge, I wouldn't want either of those two judges as a defense lawyer, because what was done here was outrageous. If he had that statement and didn't use it, it was outrageous. And I don't believe that of Monroe Inker. The last
What could
time.
he have done with the statement? I'm just following up on that. I just don't understand what he could have done with the statement other than.
Pardon me, Your Honor?
Well, what could he have done with the statement? Following up on Justice Gaziano's question to you, what could he have done?
Well, he could have elicited from Robert, for instance, that there was no, I'm sorry, from William.
William.
Yep, all right, William Robert. From William, that he received the ring from Robert as a birthday present. There was no mention of Tony wanted you to have this. He could have, at trial, William stated that I believe he stated that the closet was open, or that the key was in a drawer. In his statement, he said that that it was locked, that Robert opened the closet, and that afterwards Robert closed the closet. Robert asked him to move the body, and that he was angry with him because he wouldn't, Robert was angry with William because William wouldn't move the body. The trial of Robert was that he asked William if he would move him and move the body, and he said no, and Mr. Mazza said, well, I'll do it. There was no mention of that at all. That all of the conversation that occurred between Robert and William in William's police statement, Mr. Mazza's in another room. There's no implication at all that he heard anything about it.
You're saying that didn't come out at trial?
That he was in the other room?
Yes.
Well, at least for part of it, he wasn't, because he said when there was this argument about who was going to move Mr. Armada, he said Tony Mazza said that I'll do it.
I guess what I'm trying to ask you, is there a difference between impeaching William with his statement and using the statement for positive purposes?
Why does he have to be impeached with it?
Well, aren't you saying that he is
Sir,
contradicting?
Sir, do you recall 9 days after the event? Do you recall speaking to the police? Do you recall saying this? Is that, I mean, why does he have to impeach him with it? What about refreshing recollection? There's a transcript there of his statement. The first step is, let's get it in substantively. The notion of impeachment, I don't understand that.
Where do we go with this burden of proof where, I forget the phrase, the absence of evidence isn't the absence of evidence, or whatever that line was.
Evidence of absence.
Yeah, the evidence of absence. Where do we go with that, where Judge Brady essentially discredited the defendant's affidavit, and then Judge Giles said essentially, well, you haven't proven you didn't have it. How does that work, where it's the defendant's
I
overall
think that
burden?
you have to look at all of the evidence.
And then you look at the defendant's statement about the grand jury minutes, he didn't have them, and clearly he had them.
No, he didn't say, yeah, he said he didn't have them, right.
Right,
Yeah,
and
yeah.
Inker had them.
Yeah, but, well, he did, and that's clear.
Right.
And it's clear also, if you look at, I don't have the file,
Right,
but
that's-
I noted last time in the argument, I checked the argument, I looked at the argument, the first argument last time, and this court, I can't remember which judge it was, asked Mr. Hillman if Monroe Inker used other statements. And he said, yes, he used the statement with respect to, he used Robert's statement effectively in cross-examining, and Florence Johnston's statement Inker used effectively in cross-examining, but he said that the testimony of Francis Clifford, that the statement was not used. I actually looked at that. Francis Clifford is the woman who was with Robert and her husband and I think another man, and they were going to the beach.
Your colleague has a note for you.
Okay, thank you. Okay, yeah, I'm aware of that. So I'm being reminded of the fact that once an evidentiary hearing is ordered under this court's decision in Lopez, the actual burden is on the prosecution, not us. And they didn't prove it. But let me just answer the question. They were going out the door of the apartment, her apartment, Ms. Clifford's apartment, and they saw the police looking at the victim's car. Robert turned heel and, hustled back in the apartment, and they all went in with him. And Robert then gave the key to the car to her husband, who gave it to somebody else, and it was thrown in an incinerator, and the police got it from the incinerator. That's one of the evidence of his guilt, quite frankly. So I have two things to say. I don't think there was any necessarily reason to use the statement. The evidence that she gave was very incriminatory of Robert. But more than that, if you look at her testimony, in fact, Monroe Inker asked her 2 or 3 questions that concerned matters that had not been brought up on direct examination. We don't know that they necessarily came from her statement, but certainly that is plausible. So on the record, the only statement that we know of, as the government told you the first time, that was not used by Monroe Inker, when it would have been in his interest to use it to further the defense that was clearly the defense at trial, was the statement of William.
Well, before you get to the statement against penal interest, so didn't William on direct say that he had talked to Robert about the dead body and that?
Yes, he did.
And that
But
came
the
out on
differences
direct?
Yes, but the differences were material, Judge Lowy. That's what we're saying. And the differences were material because they were far more incriminatory of Robert, in part because they contradicted what Robert said at trial. And Robert had already testified. Robert was the first witness. What I said to this court last time, and I'd like to repeat it, is that this was not a slam dunk case. This was a case where Robert himself said that he didn't know if he said to somebody, "I may have hit him too hard." And in fact, there was a witness at trial who said that Robert told him that. I may have hit Mr. Armada, I don't know if he used the name, but too hard. So this is a case where it's one or the other. And so additional evidence that Robert was lying and trying to put it on Mazza, the analogy that I used the first time is it's like a drip of water. And you're watching that last drip and you're trying to figure out, there's the reasonable doubt. Is it pending, or is there going to be one little addition that is going to make that drop come down?
Can I turn you to?
And that's why it's material.
You've covered William's statement, and the second prong of it, and I know you said it's cumulative under Rosario.
Yeah.
The second prong is the inmate affidavits, and there's 2 theories of admissibility. One is Drayton.
Yes.
Which was analyzed by Judge Giles. But the second is, I think, a little bit more intriguing. That's the third-party culprit doctrine.
Silva
Santiago,
yes.
and O'Brien.
Yes.
In those cases. When I go through the affidavits, the 4 inmate affidavits, they essentially say, he's an innocent man, your client, and I helped.
Yes.
And I helped frame I acceded to government pressure, and I framed him.
Yes.
Have we ever said that third-party culprit evidence can come in the fact that the defendant didn't do it, where they don't name who it is? It's a weird case because, as you pointed out, you've got 2 people who could have committed the crime.
Right.
Contextually, right?
Almost
like a Salemi situation.
Yes.
But you've got an absence of saying Joe Jones, the drug dealers, the mafia killed him.
I think that you'd have to see it in context, Judge.
Okay,
and in the context of the trial, it was quite clear who the person was being pointed at. That's the first thing. But the other thing is that there's a little bit of a tension, if you will, between what we see as indicia of reliability of the affidavits, which is that these affidavits aren't these cons saying, "Oh, he told me he did it." In fact, none of them say that Robert say he did it.
Because they're
very nuanced in what they say.
Under the new trial analysis that you lay out, appropriately so, they have to be admissible. So what you're saying is, if it were a new trial, these 30-year-old inmate affidavits would come into evidence.
That's correct.
And under third-party culprit or Drayton.
That's correct.
And what I'm trying to get my arms around is, do they in fact constitute third-party culprit evidence as we understand that doctrine to be under our law now?
Someone has the right to show that somebody else did it. And I would suggest that there was a third-party culprit defense already.
By Haywood,
Pardon me?
whatever is Haywood?
Monroe Inker?
No, I'm.
Oh, I'm sorry, I don't mean the case. I'm talking about this actual trial.
Robert.
It wasn't denominated as such, but that's really what he was doing.
Yeah, Robert is.
Robert was the person who he said did it.
Yes, and Robert is also the one who in these affidavits is saying, I framed him.
So was there, by the way, a joint venture instruction to the jury in this
No,
case?
Judge, there was no theory of joint venture.
Either Robert did it or Mazza
Right.
did it.
Robert, as I understand it, was charged with murder, but when he testified before the grand jury, it was dropped, and he was not charged in any way whatsoever. He wasn't charged as an accessory after. He wasn't charged as receiving stolen goods. He wasn't charged certainly not as a murder. There was no joint venture instruction. There was no joint venture theory. This was one did it or the other one did it.
So it's third-party culprit in that you exclude one, it's got to be the other.
That's right. That, in the context of this case, absolutely. I'd love to stay up here, so if you got any questions.
I just have one, I've got a few questions, factual in nature.
Looks like you're going to get to.
Yes, thank you, Judge.
William was not before the grand jury.
Pardon me?
William did not testify
He
before
did
the
not.
grand jury.
No,
So
and
if-
that is
so
something that,
If Monroe Inker did not have that statement, he had no statement from
Correct.
you.
And I believe the government conceded that when you asked that question the first time before this
Well,
court.
then I guess I forgot about what I'd asked.
I had to watch it myself. It's a
You
Suffolk Law School.
also said they were in the same position as we were the last time, but the last time we thought there was the possibility of finding them and getting evidence from them. Does the fact, I mean, should we treat them as if they are dead, which they might be?
I can't think of how else to treat them. I might say, Judge, the last time, you suggested it, and you said, what about sending it back? And I said, frankly, Judge, I'm afraid I won't be able to find them. And here we are, like 6 years later, and I mean, and the reason it took so long is that we knew where Healy was, because I had seen him, as had my partner who testified about it. And we traced them to Binghamton, New York, and so we went out to Binghamton and the Catholic Charities, and then we traced them to Mass General, and so there was this long process. I got medical records allowed by the judge. I mean, we did everything. We actually traced them to a place in Brockton, and when we went down to talk to him, the place had burned out 2 weeks earlier, and at that point, he disappeared from the face of the earth. And I don't think he died in that, or else I would have found it, but I think you should treat them as dead. I don't know what else to say.
Okay, and going to the testimony, we haven't discussed the testimony of the bartender who referred, I guess, to the person who was with the victim at the time.
Yes.
As sort of a Latin fellow. Do we have any physical description of Mazza? I know there was a claim that was consistent with his physical description.
There was that claim. I don't know that in the record. I don't know that. I don't know of one, Judge. I cannot say categorically that there is not. But I might add that the person at trial who said that I believe it was a he. Was asked specifically, do you see that person in the courtroom? And on 2 or 3 different questions said no. So, and Mr. Mazza was clear, not only was Mr. Mazza there, but if you read the transcript,
Right, I have read the
he
transcript.
was in
I
the
also
dock.
remember Mr. Flanagan saying, how about this fellow right here?
Exactly.
Objection sustained. How about a young fellow? So, no, I mean, Flanagan beat that over the head.
Right, and he was in the dock. So there was no question about this, I mean, not allowed at this point, but at that point, he was in the dock, and if you read the transcript, somebody says, the man in that box over there, so it's clear he was in the dock.
So, but in terms of the description of him, do we have anything in the record which would allow us even to say whether or not
I don't know.
Mr. Mazza was dark-skinned and looked as if he was Spanish?
I don't know of anything. I cannot say yes or no, Judge. I'm ignorant. I'm sorry on that.
Is there anything in the record that establishes the time of death?
I think, I don't really know the answer to that, Judge. I think.
Because wouldn't that be relevant in terms of the people who said that they saw things going on? I
think there was just an assumption that it was in the evening, but I don't remember the medical examiner's testimony on that.
Yeah.
You know, Judge, I probably should know the answer to that, but I don't. I'm sorry.
Okay.
Okay, thank you.
Thank you, Judge.
Ms. Kesselheim.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. And I would also acknowledge former Assistant District Attorney Zachary Hillman, who wrote the brief on behalf of the Commonwealth. The Commonwealth respectfully requests that this Court affirm the order denying the defendant's motion for a new trial and affirm his convictions. And I'll begin with William's statement, where my brother began his argument. The motion judge correctly found that the defendant failed to meet his burden in proving that Attorney Inker did not have William's statement.
Let's stop there. What do you say to your brother's argument that actually the burden was on you?
It's the defendant's motion, Your Honor, and it was remanded for factual findings for this specific purpose. So it was remanded for factual findings with respect to his motion, arguing that the statement was newly discovered, and it was remanded for factual findings to make that determination. As this court has found in Comita, the defendant is the one who bears the burden to prove facts neither agreed upon from the record, nor apparent from the face of the record. And this court acknowledged in Comita that it would be unfair to put the burden of proof on the Commonwealth because the predictable consequences of delay, and here we're talking about 45 years, would mean that post-trial the dispute would more likely be resolved in favor of the defendant. And the longer the defendant delayed, the more likely that would be the result. So it was remanded for this purpose. My brother did submit affidavits of several, though not all, of his clients, the defendant's former attorneys. He did not, however, call any of those attorneys, many of whom are still members of the Massachusetts Bar. He did not call any of those attorneys as witnesses. And so we're just...
Their statements admitted in evidence?
Excuse me?
Were their statements admitted?
Affidavits,
I'm sorry, their affidavits were they?
Their affidavits were accepted by the court, and the court actually, Judge Giles credited their affidavit.
There was nothing contradicting those affidavits.
Excuse me?
There's nothing contradicting those affidavits.
No, but if you read the affidavits, they don't actually shed light on whether Attorney Inker had the Williams statement at the time of trial.
Was there a motion by Attorney Inker at any point for production of all statements?
Yes. So and the Commonwealth agreed to that motion. There was also a motion for the production of a witness list. So that entitles the Commonwealth, I think, to a presumption that any statements that were in the Commonwealth's file were turned over to Attorney Inker at the time of trial.
But what do we do with the fact that he didn't make any reference to anything in the prior statement when he cross-examined William?
We make of the fact, as he argued in both his motion for a required finding, which I would direct the court to the transcript, volume 4 at pages 100 to 101, and also in his closing, I direct the court to volume 6, page 42, where he states that Williams' testimony undermined Robert's testimony. He basically, the crux of the defense was that Robert was the killer, not the defendant, and that Robert also, and he says this repeatedly in his closing, Robert was a liar. And Williams' statement would tend to support the theory of the defense that Robert was the killer. According to Williams' statement, Robert is the one who...
You mean Williams' testimony, not Williams' statement?
Sorry, I apologize. Yes, Williams' trial testimony. He testifies at trial that William was the one who brought him into the house. William was the one who unlocked...
Robert, you're getting confused. William says Robert brought him into the house.
Yeah, okay. I apologize.
Okay. But, I mean, I understand. His purpose, I mean, this goes to the issue of whether the purpose was impeachment or the purpose was to elicit additional information. But if Inker has no prior statement of this key witness, he cross-examines him at his peril, which would arguably explain why he has two questions on cross because he doesn't have any prior statement. If he's venturing into the unknown, if he asked any question beyond the direct. I mean, isn't that powerful evidence that he didn't have a statement?
No, because the testimony that William gave at trial supported his theory of the defense.
He didn't testify at trial that, William did not testify at trial that Robert cut the cord on the victim in the closet, did he?
No, but
And isn't that powerful evidence of the fact that this guy who walks in and suddenly discovers a dead body is now so familiar with this body that he actually is cutting the cord in the closet? I mean, that's unusual behavior for somebody who comes home and finds a dead body in his home.
all of the behavior by Robert, as testified at trial, was unusual for a person who comes home and finds a dead body in his home. I don't disagree with that synopsis.
Which arguably is a reason why Robert's testimony should be viewed as, I mean, the man was found dead in Robert's home.
Correct, and that evidence was before the jury. And William's testimony was that Robert was the one who showed him the body. Robert was the one who unlocked the closet using a key that Robert obtained from a drawer. They had a conversation of about the body. I would note that the content of that conversation didn't come in at trial, but that would have been hearsay. He couldn't have admitted the content of that conversation at trial. Robert was not on trial. I would correct one thing. He was charged as an accessory after the fact. Robert was charged as an accessory after the fact.
I'm sorry to interrupt you, but there's a fact that I just get very confused about. Was there testimony by William at trial that the defendant was in another room?
Yes.
There was trial testimony as to that.
Yes, and
So the statement wasn't necessary for that.
It was not necessary for that. And his statement was that he had been to the apartment, but not a statement, his trial testimony was that he had been to the apartment on a number of different occasions, and that in all of the occasions, the defendant was in the parlor. The defendant was never involved in any of this interaction regarding the dead body in the closet. It was all Robert. So in that sense, William's testimony supported the defense's theory that Robert was the one responsible for this. Robert was the one who showed the defendant's off watching TV in the parlor. Robert's the one who shows him the body, unlocks the closet using a key that Robert obtained from a drawer. They have a conversation about the body, and that Robert gives him a ring that was later identified as the victim's ring. And again, in arguing his motion for a required finding of not guilty and his closing argument, the defense attorney Inker relies on William's testimony as supporting his theory that Robert's a liar and that Robert's the one responsible for this murder. I would also make the point that William was not an unknown individual. If he was an unknown individual at the time of trial, one would have expected that Attorney Inker would have objected when he was called as a witness. And given that he was the defendant's brother and that he was a witness at trial, and that Attorney Inker had an investigator at the time of trial, certainly his statement would have been discoverable within the meaning of Rule 30 at the time of trial.
Can you take just 30 seconds to do a short marshaling of the evidence that supports the murder conviction?
The defendant's, yes. So certainly Robert was the principal witness. Robert testified that he met the defendant. He came home on the night of June 30th, late at night. He had allowed the defendant to stay at his house. He came home. The defendant was standing over.
So there's nothing other than Robert's testimony?
Regarding
implicating the defendant?
No, I'm just, you asked me to marshally argue. So other than Robert's testimony. Other than Robert's testimony, there was the testimony of Florence Johnson, who saw Robert and someone who looked like the defendant outside of Bowdoin Street at 384 Bowdoin Street.
Was she familiar with him?
Yes, she was familiar with Robert Anderson. She was friends with Robert Anderson's mother.
At what time was this?
That was between 2:30 and 2:45
So the answer to the
a.m.
question that I asked counsel about whether or not the time of death was established?
It was not, to my recollection, established, and I don't believe it's listed in the autopsy report. The state of decomposition of the body was too
Okay.
bad at that point.
Yeah.
But Robert testified that he left a bar in the combat zone around 2 a.m., that he walked home, and it took about 45 minutes.
Right.
So according to him, he gets back between 2:45 and 3 a.m., and already the man is dead.
Right.
And the bartender sees the victim leaving the bar at 2 a.m.
The bartender leaving the victim, yes.
So we're talking about 2 a.m., the victim leaves the bar, and the bartender knew the victim, and then he's dead
When,
by
yes,
3
approximately,
3
right.
a.m. So we're talking about a period of 1 hour.
The early morning hours of, from July 30 from June 30th to July 1st, approximately.
And we don't know whether or not this person Miss Johnson saw them before or after the killing. She says they're outside.
Correct, and it was Robert's testimony that after he saw the body and after Robert saw the body, that he asked the defendant what had happened. The defendant said they had a struggle, and they said they needed to move the body and that they would move it the next day. And then he left in a cab. And then there was testimony
In a cab.
that the defendant left in a cab.
Is there a victim's car? Right?
There was.
So he didn't take the car?
He didn't take the car that night. The car remained at the property. There was also testimony,
It was Robert who was driving the car.
both of them were seen driving the car at various times in the subsequent couple of days. Francis Clifford saw the defendant driving the victim's car on July 1st around 4 p.m. That's at transcript 157 to 160. Paul Kelch, who was a store clerk at Salinger's, he testified that the defendant tried to purchase items using the victim's credit card. Officer John T. Murray testified that he executed a search warrant at the defendant's apartment, and he found a rent receipt. The defendant was in fact staying there, and found the victim's identification and license in a drawer in the defendant's apartment.
The defendant's apartment was not it was not Robert's apartment?
It was the defendant's apartment, a separate apartment. That was, I apologize, I don't have the address, but that
Okay,
was
I was
I believe it was
confused.
Clifford Road, but I'm not positive about that.
Confused.
Yeah, no, different apartment.
Okay.
And there was Jerry Leonard, who saw the victim at the Napoleon Club and left with a person who arguably looked like the defendant. To answer the court's question, the jury, he described what the individual who left the bar looked like. The defendant was in court in front of the jury. The jury could determine whether that description matched the description of the defendant.
But we can't.
Well, no, I mean, and again, this happened a long time ago. I don't know if his appearance changed between the time of the incident and the time of trial. I can't speak to that. But certainly the jury could evaluate that evidence.
That same person said he could not identify the defendant as the person.
Correct. In court that day. He couldn't make an in-court identification. He could describe what he saw the night of and give a physical description of that person, including hair, facial hair, height and weight, but he did not identify that person as the defendant that day.
Let me ask you a legal question. As to the inmate affidavits, there are two theories of admissibility that are proposed by the defense. One is Drayton, and the second is third-party culprit evidence. You didn't address third-party culprit admissibility in your papers. What do you say to the argument that the inmate affidavits, because they say the defendant didn't do it and the defendant helped the police frame, that Robert helped the police frame him, that it is third-party culprit evidence, because if you exclude one in the circumstances of this case, it's got to be the other guy?
No, they're not third-party culprit evidence in this case. Robert never says, it was me, I'm the one who did it. Certainly, that was the defendant's theory of the case, but he never says to any of those affiants that, that he was the one who killed Peter Armada.
Why does a third-party culprit have to be unknown? Where does it say in the case law that for hearsay admissibility under third-party culprit, that the third-party culprit has to be unknown?
Well, it doesn't say that, do you mean known, that it has to be?
Unknown. In other words, in this situation, there is a defense, Robert did it. He is not the defendant. Why isn't he a third-party culprit such that if you satisfy the foundation for hearsay under third-party culprit, it would be admissible?
Because he's not, he does not implicate. I'm not sure if I'm understanding your honest question.
It's a simple question, which is, you're saying that there's no third-party culprit.
Basis for admissibility of these
Right.
affidavits.
And I'm saying, well, why isn't there a third-party culprit issue if the defendant is pointing to somebody else specifically who did it?
Well, certainly, that evidence of a third-party culprit being Robert was certainly admitted at trial. I don't know how.
Here's the question. The issue that Justice Gaziano just asked about was, okay, put Drayton aside. Third-party culprit law allows hearsay to be admitted in certain circumstances. And quite frankly, the standard is not as high as it is under Drayton. So if there's a third-party culprit issue here, why isn't there an issue that might allow the jailhouse affidavits to be admissible?
Well, because there's no basis to in this case, to determine that those affidavits are reliable at all. So there's no reliability that has been shown with respect to those affidavits.
But that's the Drayton analysis.
You're in a Drayton box.
Yeah, go to the third-party culprit as far as you have to satisfy the third. There has to be substantial connecting links, and here the defense is arguing the substantial collecting, the links involved in here under O'Brien and Silva Santiago is the circumstances of here where they're pointing the finger at each other, essentially.
Right, and that would not have been new evidence.
Well, it's new evidence that Robert said he framed him.
Yeah.
That's new evidence.
Well,
I get what you're saying, that we have 30-year-old
affidavits
from arguably cooked up by a bunch of inmates.
Correct.
That's your argument, and that may well save you for Drayton. The question I've got that you didn't address in your papers is, how is it not third-party culprit? Judge Giles found in a footnote that there were impeachment material, but you didn't address that, and I'm giving you opportunity to address it here.
that they were not impeachment material?
Judge Giles in a footnote said, this isn't third-party culprit, this is impeachment material.
Right, and
And the defendant, his secondary argument was, if it isn't Drayton, it's third-party culprit. You didn't address third-party culprit in your papers, and we want to give you the opportunity to do so here.
yeah, and in this case, again, I think it goes back to what Justice Lowy was asking, which is there's no, he's not pointing, there's no indication that it was a third-party culprit. He's not saying, in the affidavits, nobody's saying this other person, known or unknown, was the one who committed this murder. He's simply saying, I lied, and the veracity of Robert's testimony was exhaustively cross-examined.
Right, put that aside, but we have to look at, you're telling us to look at the four corners of the affidavit, and if it doesn't name a suspect other than defendant didn't do it, it doesn't constitute third-party culprit.
Implicate anyone else other than the defendant. So no one else is implicated. He says he lied at trial. They all say that
He also says the defendant didn't do it. He's an innocent man. That's what the affidavits say.
Yes, and again, I have to go to I think it's important for the court to consider the veracity of the affidavits. If I have 1 minute.
Do you want to submit a letter and analyze the third-party culprit evidence?
Yeah, certainly, I'm happy to do that. I would also just direct.
Wouldn't be a bad idea.
Pardon me?
Probably
No,
wouldn't
I
be a bad
understand
idea.
that, and I would certainly.
Probably want that from both sides, don't you think?
Yes. I
Do
mean,
that.
Mr. Kuna did too, but if you both, I'd invite both of you to further analyze the third-party culprit admissibility issue, given the four corners of the affidavits.
I would just.
Heard.
We'll certainly do that. I would just point the court to.
Well, hold on that last point, by the way, and you want to.
There's more homework.
You want to focus, yes, there's more.
For homework.
Get a chance for extra credit.
It's the focus on the need for corroboration in the context of third-party culprit as opposed to Drayton, because there are third-party culprit cases that talk about corroboration, but it's not required as the foundation. So it's a pretty complicated issue that Justice Garzano is asking.
Yes, and certainly the Commonwealth will certainly submit that supplemental briefing. I would just add one point, if I may. The Commonwealth did admit at evidence, and this court is certainly can take judicial notice of other filings that are in the clerk's file, and I would point the court to Exhibits 1, 2, 3, and 4 from the evidentiary hearing. Exhibit 1 was a bill of service.
Before Judge Giles?
Yes.
Okay.
Exhibit 1 was a bill of services for attorney Bernard Grossberg, who represented the defendant in the 1976-77 period. And that bill notes that he conducted multiple interviews on 3 separate dates with possible inmate witnesses regarding a motion for a new trial. And that was in the 1976 to 1977 timeframe. Exhibit 2 is his motion to withdraw. And he says that after extensively reviewing the case, he found no meritorious legal or factual grounds that could be raised on behalf of the defendant in any sort of post-conviction proceeding. Exhibit 3 was Attorney Zalkind's motion to withdraw. He was appointed in 1979 and withdrew in 1980, having said he reviewed the case and interviewed witnesses and found no meritorious grounds to be raised. And then Exhibit 4 is his affidavit in support of his motion to withdraw, where he notes that he interviewed various potential witnesses, but he found no meritorious factual or legal issues that could be raised. And I think that it's reasonable to infer that the possible inmate affiants referenced by Attorney Grossberg in that time, right around when the affidavits were obtained by the defendant, were the inmates that we're talking about here, and that he considered that, and he did not find them to be credible, such that he would raise the claims related to their affidavits in.
Are those part of the record? I don't remember seeing those.
Yes, they are. They're in the clerk's file. I found them in the clerk's file, and they were also entered.
Is it in the record appendix here or something?
They're not in the brief. They weren't attached to our initial brief, which I didn't author. I did admit them as evidence in the evidentiary hearing before Judge
We don't have
Giles.
them as part of our record, is it?
You do.
do.
Before
you
they're
point
part of
me to
the trial file, the trial
You have
records.
to go to the clerk's office to get this,
Um,
because we don't have them before us. Or do we?
I thought that the evidence, or
I didn't see it, if
I can submit those as well with the accompanying supplemental memorandum. They were accepted by Judge Giles in evidence. I don't know that they've been transmitted here, but they're certainly.
I didn't see them, but that doesn't mean anything.
Unless the court has further questions.
I do have I'm not quite sure how to approach this. There was a sense that I had that the defendant was developmentally disabled. Was there evidence to that effect?
That was raised in his direct appeal. So his direct appeal.
Referenced in our decision in 366 Mass, where they talk about he has a 72 IQ.
Correct.
Okay.
Correct. And when this court reviewed that claim, the court declined to either reduce the verdict or order a new trial. And that was the basis of the
Was it
appeal.
before Judge Travers? That was Judge Travers who decided that?
That was this court on appeal.
I'm sorry.
The first time.
Yeah,
Yeah, but
Back
no-
in 1974.
Chief Justice Hennessy, I believe, wrote the opinion.
yeah, that's right. I have another question, which is, I don't know if there was evidence to this effect or whether I just get the sense of it, that this may have been, these bars may have been gay bars.
Yes, well, I don't know about I don't want to speak to all of the bars. I know that in presenting his alibi witness, the defending, the question was brought up that whether at least Jacques' bar, which was one of the bars that apparently the defendant and his alibi witness went to that night, apparently there were gay patrons there. I don't know that he would I think he said there were gay people there and there were non-gay people there.
Yeah.
Wasn't there, didn't the DA make reference to that in closing?
Yes.
Something we would never permit today, I assume.
There were, reading the trial transcript from 1972, it's difficult to look at a 1972 trial through a 2019 lens, certainly. And we have, and I think that's important when considering the context of this case as a whole, which is the way that trials were tried then was different. The types of evidence that were available to both the Commonwealth and the defendant were different. So it is very difficult to look at a 1972 trial through a 2019
But
lens.
the jurors were vetted or not vetted, prospective jurors being vetted or not vetted, that was different then too.
Yes. Yes. But again, I do think with respect to at least the witness affidavits, there's, after the first motion for a new trial, which was submitted pro se, which attached the inmate affidavits, was submitted, the defendant was represented by counsel, both Attorney Grossberg and Attorney Zalkind, before the next motion for a new trial was filed, and neither of those attorneys opted to press those motions, and subsequent attorneys up until the present motion did not. There were other motions for a new trial filed that did not press the issues with respect to the inmate affidavits.
Okay, thank you.
Thank you.
Take our break.
All rise.